This conference will now be recorded.
Now I'm gonna miss it. We need to like go to lunch with him or something. Yeah. There you go. Okay. All right, thank you. All right, well, good morning, everyone. My name is Sandra Brown. I am the administrator for Barzil Health and Rehab Community. I did come in last night, so that was, didn't have to drive this morning, so that was kind of nice because I'm not a morning person. So thank you guys I'm glad you guys are here. And last time I came to this class, I had one person in here and everybody else was on Zoom. So hello, everybody out there. But it went really well. And I hear I have an HR person in here. Which one of you does HR? You? Okay, good. Prior to being an administrator, that's what I did. I did 20 years of HR. Now, I've been administrator for almost 5 years now. And I have, so I've been little bit of HR, but probably out of the loop of some of the up-to-date laws other than, everything I need to know as an administrator for COVID related stuff has really kind of got us all in a bind, but well, we're getting better. We're kind of getting through all that, but it really played a huge role in how we had to make some changes in how we worked and how we exercise, our way of thinking, how we had to learn, how we had to communicate with everybody. And just between work and juggling home stuff, all of those things. Zoom meetings. Good morning, how are you? So I've never been to so many Zoom meetings in my lifetime prior to this past year. But so I'm glad you guys are here, and I'm going to teach you as much as I can. I'm going to get through the basics. And if you guys ever have any questions, please don't be afraid to pipe in and just ask me your questions. So are you guys working in long-term care now or assisted livings or anything like that? Yeah? Okay, good. All right. Are you excited about becoming administrators? Good. All right. That's exciting. I was too. I was very nervous, I'm not going to lie. But I started out as an assistant administrator and prior, until I got my license. But doing that, I remember the owner calling me and saying, do you want to come be my administrator? And I'm like, what does that mean? So that's where I started. And then I ended up here. So I'm glad. So again, we're going to talk about human resources today. So what is human resources? It is used to describe both the people that work in the company or organization and the department that is responsible for managing resources related to those employees. Okay, so your human resources management is focused on a number of major areas, which includes recruiting and staffing. That has been very, very hard. In fact, I don't know, there's a lot of people out there that don't want to work anymore. So it's very, very hard to recruit. So you got to kind of think about being creative. You can only offer so much more money, or so you have to get more creative, because it's not always about money, but it seems like a lot of people are staying home because of unemployment. It's better for them to stay home because they're getting paid to sit there. So we got to figure out what can we do to bring those people back in. You got to get creative there. Compensation and benefits. Benefits are real important. Training and learning, labor and employee relations, and organizational development. Okay. So human resources is responsible for managing job recruitment, selection and promotion, developing and overseeing employee benefits and wellness programs, developing, promoting, and enforcing personnel policies, promoting employee career development and job training, providing your orientation programs for new hires, and providing guidance regarding disciplinary actions, and serving as a primary contact for work and injuries or accidents. So where you are at now, do you guys have a new hire orientation program? Because a lot of places, I know prior to me coming to a nursing home, long-term care field, I used to, 10 years I worked in a assisted living, independent living facility, and part of my job too, I did new hire orientation. And it's hard sometimes in this field to get everybody together My whole interview process was a lot different too, because I knew that if I had applicants that come in, I could maybe go through 10 applications and I could actually pick and choose who I wanted, and that's not really the case anymore. It's like when they walk in the door, you don't want them to walk out, depending, because you don't want warm bodies either. You're going to know probably within just a few minutes whether or not that person's going to be a good fit for you as well. But new hire orientation, or just orientating even out on the floor, depending on the position where they're at, is very important, because nothing like job burnout or someone not learning something and them getting frustrated and just walking out because they don't feel like they've been trained well. So that's very important. So if that's something you don't have, or maybe if you have an HR person already in your department or in that facility, please be sure and get with them and talk to them about what you can do to see where they are at with that, or maybe even revamping the process or anything like that, because it is very essential for that. And that will help you with your staffing and, keeping the turnover from being so wide. Okay. Your primary function for HR is to ensure that the company complies with federal and state regulations or labor and employment laws, such as your Fair Labor Standards Act or FLSA, your Title VII of the Civil Rights Act of 1964, and your Occupational Safety and Health Act of 1970. Just some of the few things. So OSHA, I've not had any OSHA audits, but it's, you work with all kinds of things. If you have any workplace injuries or anything like that, you do have your due diligence and making sure that things get filled out properly, making sure that that staff member is taken care of, things like that. So Fair Labor Standards Act. It is one of the most important laws for employers to understand, since it's set out a wide array of regulations for dealing with employees. Okay. FLSA of 1938 talks about your minimum wage, still $7.75, or $7.25. Very hard for someone to live on that wage. In fact, I don't know anyone that actually still pays that type of wage. Maybe, I just don't know, because a lot of people just can't live that way. Pretty close to it, but overtime pay, child labor provisions. Okay. You don't want to put your little 12-year-old in there to go to work for you, right? Employees whose jobs are governed by FLSA are either exempt or non-exempt. Can anybody tell me what that means? Does anybody in here know what that means?
The ability to be like fired, like something to do with their time and being fired or something.
So you're exempt versus non-exempt. So that's there are several things. It depends on how you're paid. It does depend on what kind of work they do, and it does depend on salary versus hourly rate, because you can't, if you're on an exempt employee, you're also not going to get overtime pay to your salary. To be an exempt employee, you must be paid at least $23,600 per year, or $455 per week, and be paid on a salary basis, and also perform exempt job duties. And we'll kind of go over some of those here in just a moment. There is a duties test. An employee who meets the salary level test and also the salary basis test is exempt only if he or she also performs exempt job duties. They can be called executive, professional, and administrative. Administrative can also include doctors, your RNs, but not your LPNs. Okay, they can also be exempt depending on their duties, depending on if they supervise a department, things like that. Okay. Major EEO laws. So your equal pay of pay. I think I'm still trying to wake up. Of 1963, it does require all employers covered by the Fair Labor Standards Act and others to provide equal pay for equal work, regardless of sex. Your Title VII of Civil Rights Act of 1964 was amended in 1972, 91, and 94. It does prohibit discrimination in employment on the basis of race, color, religion, sex, or national origin. It has created the Equal Employment Opportunity Commission to enforce the provisions of Title VII. Your Age Discrimination and Employment Act of 1967 was also amended in 1986 and 1990. It prohibits private and public employers from discriminating against people aged 40 or older in any area of employment because of age. Exceptions are permitted when age is a bona fide occupational qualification. There also has a Pregnancy Discrimination Act. It does broaden the definition of sex discrimination, which to include pregnancy, childbirth, things like that. Your related medical conditions. It does prohibit employers from discriminating against pregnant women in employment benefits. Your Americans with Disabilities Act of 1990, it does prohibit discrimination in employment against people with physical or mental disabilities or the chronically ill. Enjoins employers to make reasonable accommodation to the employment needs of the disabled. And it does covers employers with 15 or more employees. Okay? Does anybody have any questions about that yet as we move on? I really am sorry. I try not to make this as boring as possible. I used to throw candy at people, but probably should have brought some. Okay, we're gonna have a quiz. So which of the following is not a protected characteristic by Title VII of the Civil Rights Act of 1964? Anybody tell me? Status as a parent. Is that the speaker or did I hear that? Okay. So status as a parent. So it does protect sexual orientation, national origin, and race, but it will not, it does not protect your status as a parent. Okay. Family and Medical Leave Act, or FMLA. Let's see. I just wanted to show this to you. You can also go onto a website for the Wage and Hour Division, and there is an employer's guide to the Family and Medical Leave Act. This is actually a very good guide for any of you to follow. So when you think about it, or your HR department, if they don't have it, this is something for them to go by. If you ever have any questions about that, okay? So the Wage and Hour Division. Okay. FMLA entitles eligible employees of covered employers to take unpaid job protected leave for a specified family and medical reason with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave, and it guarantees unpaid leave, okay? Your employee, when they return, they will return with the same or similar position, pay, conditions, and benefits. But in order to be eligible, there are a few things. So an eligible employee, it's a worker for a covered employer, which is got to have 50 employees or more within a 75-mile radius. Had worked for the last 12 months, but does not have to be consecutive. So just remember that too. It does not have to be consecutive, and we'll go over that here in just a few minutes. Breaks in service cannot exceed 7 years unless it's for military service. And they've worked for you at least 1,250 hours of work in the 12 months preceding leave. So it doesn't matter if that person is part-time or full-time. If they work for you at least 1,250 hours in that 12-month preceding leave, then they can qualify for FMLA. And just remember, unpaid. But say if you have benefits like a vacation or paid time off or sick leave, I would always recommend that you don't just let that balance or whatever their accruals are just sit out there. So if someone is on an unpaid leave, and if they have anything in their PTO balances, vacation sick, you're going to want to use that. Make sure you take that from them. And then that way they're still getting paid. It covers any of their insurance premiums should they be enrolled in insurance. You get to a point where maybe they don't have vacation or anything like that, and they're on 12 weeks of leave, and it's up to their employer to also contact that person so that if they want to keep their benefits, they're paying for those premiums as well while they're on leave. So your leave entitlement, again, 12 weeks of unpaid leave. It can be for a birth or adoption, foster care of a child, a serious family medical problem, or even your own personal worker's serious medical problem. I think I went backwards I just went too far. Sorry about that. I skipped a slide or the bottom piece of that. So retention, that's for seniority, health insurance covered, credit for previous service, and accrued retirement benefits as well. Okay, so what's a 12-month period? So as an employer, you have a pre-established designation for a 12-month period. So everyone always remains just automatically calendar year, okay? So your calendar year, again, January 1st to December 31st. It can be any fixed 12-month period, like the employee's anniversary date, or if you run on a fiscal year. The 12-month measure forward would begin the first day that the employee takes FMLA, or your rolling 12-month. Under a rolling 12-month period, the employer looks back over the preceding 12 months. Okay, employer verification. It can require certification from a medical professional, also can require a second or third opinion from other health professionals, and can require a periodic reevaluation of health conditions. So if you've got somebody that's out on some sort of medical leave, they have a fit for duty test too. You can have them fill out a fit for duty form. Those you can even Google and you can find those if you don't have your own forms or anything like that. Sometimes it does require a second opinion, whether or not that person is safe to come back to work. You know, you're gonna have to look at, you know, because sometimes it can also roll over into workers' comp. You know, you want to look at not just are they going to be on any type of light duty or anything like that, because you don't want them to, you know, come back to work and be able to re-injure themselves or anything like that, just depending on what the problem is. I mean, it may not even be anything work related or anything like that, but it can. So a serious health condition. So the Department of Labor regulations, they talk about a serious health condition. So the expanded definition is broad and intended to cover various types of physical and mental conditions. And it is intended to cover conditions or illnesses that affect an employee's health to the extent that he or she must be absent from work on a reoccurring basis, or for more than a few days for treatment or recovery. Illness, injury, impairment, or physical or mental conditions. The term is not intended to cover short-term conditions for which treatment and recovery are very brief. Inpatient care, so if someone is in the hospital, hospice, or residential medical care facility, incapacity and treatment also involves continuing treatment, pregnancy or prenatal care, chronic conditions, permanent or long-term care conditions, or conditions requiring multiple treatments. Can the flu or a cold be considered a serious health condition? Does anybody know? And now I guess we have to look at COVID too, right? Whether that can be a serious health condition, because it can be, but it's only if that individual is incapacitated for more than 3 consecutive calendar days. Okay. I can tell you guys one good thing that you might want to hear. I have never ever taken this class all the way up till noon, so I promise you, you will not be. If you get a little bit bored, or I wish I could give you some wake up stuff, but I will not keep you till noon today. And so you might get, I say that unless we have a whole bunch of questions. So you might get to take an extra long lunch today. Okay, good. And you guys have my cards too, and I'm not sure, but if you didn't get my card, I do have one right up here. And I'll even give you my personal cell phone number if you need it for anything. My email address is on there. You can also email me too. I do remember, and I had a class last November where somebody had asked me to email them something, and I don't know, I got back and a lot of things happened, and it literally hit me last week, and I'm like, I never followed up with that person. So now I feel really bad. So I'm going to be going back when I get back to the office and checking that email, and I'm sending in a huge apology, because most of the time, yes, I will follow up with you. I will try to send you information if you request it. I will try my best. Okay, so let's talk about that fitness for duty. So the employer should have a policy. It says may have a policy or practice that requires employees in similar job positions to take leave for similar health conditions, to provide return to work or fit for duty certification from employees healthcare. provider, showing that the employee, again, is able to resume work. You may request that fit for duty certification only with regard to the particular health condition that caused that employee to take that medical leave of absence. If you do require fit for duty certification, it must provide the notice of that requirement or whether the certification must address the employee's ability to perform the essential function of his or her job. When you guys fill out, and maybe you don't know, I don't know, when they have their applications, do you ever have a health questionnaire at the end of it? Obviously, we also have to be careful with protected health information or not violating other laws like HIPAA and things like that. But there are certain things that you can ask. You know, you can go over some items with them and say, are you able to perform these duties? And that's an okay question to ask that person. Because if they can't perform certain positions or certain duties, then they may not be the best fit, you know. And it could be as simple as, can you lift 50 pounds or more, something like that. Okay. And you can also make accommodations too, and we might get into, I'm pretty sure I'll get into it here in a few minutes, but if you have somebody that comes on and maybe under ADA, they have a disability, or maybe they have a hearing disability. You know, maybe they want to apply for a receptionist position. It doesn't always mean you have to keep them, because are they going to be able to hear? They answer the phone. There's certain things, certain technologies that you can do to add, as long as it's not costly. And we'll go into. I think I have it in here. If it doesn't cost the employer a burden, you know, as far as money goes, to be able to get that person on there. So in general, a fit for duty certification may not be required for each absence taken or an intermittent or reduced leave schedule. However, the employer has a reasonable belief that the employee's return to work presents a significant risk or of harm to the employer or the others. The employer may require that fit for duty certification up to once every 30 days, you know, just depending on the situation. And as long as the employer has provided the required notice regarding any fit for duty certification requirement, the employee's return to work may be delayed until the fit for duty certification is provided. Okay, so, and they're going to want to get with their physician, their provider, and they'll be able to get that to them and talk to them about what they can and cannot. But it cannot delay the employee's return to work while making that contact. Okay, we have another quiz. We'll keep you on your toes. Under the Family and Medical Leave Act, how many hours would Seth have had to work in the previous 12 months in order for him to take time off to care for his wife and a new child? 1,250 hours, that's right. Good job. Does anybody have any questions up to this point? No? Okay. Under FMLA, an employee could potentially take leave for 24 weeks in a row. Is that true or false? False? It is actually true, and I'll tell you why. Because under your calendar year and a fixed 12 month, an employer could take 12 weeks, maybe at the end of the calendar year, and now you've rolled over into the next year, and they can take another 12 weeks at the beginning of that new year. Okay, so it can happen. And what a burden for the employer, but it can happen. So that's something else you'd have to be very careful with, especially if you're running on a calendar, you know, basis. So, okay. Any questions about FMLA? And again, you can go to your wage and hour division, and you can get this packet. It really is nice and it's very handy. So, also the Oklahoma Department of Labor, it has some employment standards division for wage and hour stuff. There's some frequently asked questions. This is also another very handy document that you can get. So like, how do I file a wage claim for wage and benefits, things like that. A lot of people ask, are breaks and lunch periods mandatory? And neither federal and I don't know how many people know this, but neither federal nor state law requires employers to provide breaks to employees ages 16 and older. Mandatory break laws only apply to children under the age of 16. Your break and lunch periods are considered benefits and remain the discretion of the employer.
Does that include lunch too, or just?
It does, but you know, you can, but who wouldn't want to be able to take a lunch, you know, like that? So, and it also you want to think about the number of hours, I think, but it is not mandatory. And again, it is a benefit. So, okay, so let's talk about OSHA now. I worked for that assisted living, independent living facility, and I had OSHA walk in my door one time. And just like when you have state surveyors walk in your door, it's like your heart, everything just kind of falls. Even though you know you got to be prepared for it, you always want to work and live each day as you want to be state ready. You want to always be ready. You always want to comply with the laws. But it still kind of takes your breath away. You're like, oh my goodness, what do they want? What are they looking for? What can I do? I hope everything's good. You kind of go there too with OSHA. So, because they're looking for life safety, they want to make sure that everything is safe and for your employees and the employer as well. So what standards or regulations exist for the hazards that you have identified? So it does require record keeping. It does require most employers with more than 10 workers to keep a log of injuries and illnesses. I do keep a log as I'm required. Workers have the right to review the current log as well as the log stored for the past 5 years, so make sure you save this document. And workers also have the right to view the annually posted summary of the injuries and illnesses, which is your OSHA 300A log. And I believe it posts every year from February to May, or April, sorry, from February to April. So has anybody ever seen this 300 log, OSHA 300 log? No? Your HR person will know a lot about that, but that's something that you can look at too. But it is used to document and classify work-related injuries and illnesses and the severity of each case. So anytime there's an injury, these are one of the things that not only are we notifying works comp and filling out those forms, we're also having to document those injuries and figure out, you know, the severity of each case. Your annual summary shows totals of the injuries and the illnesses for the year in each category. And the summary must be posted in visible location. Oh, there it is, February 1st to April 30th of each year. Okay. The Patient Protection and Affordable Care Act of 2006. It was signed into law by President Barack Obama on March 23rd, 2010. It was amended by the passage of the Healthcare and Education, not Obama, sorry, Reconciliation Act of 2010. And the goal was to reduce the number of uninsured by 32 million in 2016. Challenges in healthcare reform. It does require most employers to provide health insurance to employees. There's a $2,000 penalty per employee. There is a YouTube video, which I'm not going to show you guys this, but do you have a copy of these slides, by the way? Okay, so that YouTube video is on there too, if you want to go take a look at it sometime too. And this fact, it might need to be updated, I'm not sure, but approximately 96% of employers are small businesses and have fewer than 50 full-time equivalent workers and are exempt from the employer responsibility provisions. All right. Quiz. So under your Patient Protection and Affordable Care Act and its amendment, Healthcare and Education Reconciliation as of, I'm sorry, I think I started asking a different question. Sorry, my bad. An employer with 50 or more employees is required to offer affordable healthcare options for both the employee and the dependents. Is that true or false? True. True. That's right. Okay. Let me see where I'm at. Does anybody have any questions yet? We good? Again, I just try to slide right through these, so if you have any questions, be sure to ask. All right, this discrimination. All right. What is it and how do we cope? Okay. Diversity. It is the one true thing that we all have in common, right? Diverse, again, we are all distinct in kind. We are unlike, and we have a variety in form. We're diversified. So, or the fact or equality of being diverse, which is there's a difference a point or respect in which things differ, or if that's, the definition of diversity and diverse. Okay. So your diversity will encompass more than the differences in race, religion, national origin, disabilities, age, gender, or your sexual orientation. Diversity includes respecting and appreciating individual differences and ensuring that all employees are included as full, contributing, and influential team members. All right, understanding diversity. It does require supervisors to be sensitive. How many times have we heard sensitive? Like a lot, right? You gotta be sensitive to everyone, no matter what. Using common sense, being respectful, paying attention, avoiding stereotypes, not using any slurs, slang, or negative inferences, and avoiding snap judgment based on first impression. Snap judgments to me can be very hard because sometimes, and we all do it. I mean, I'm pretty sure we all do it. You've got a person that you just meet and you're already making a first impression about that person when they walk in. You're looking at that person and how well dressed they are, have they bathed, how are they answering their questions, like if you're asking them questions, how are they responding, things like that. I can remember sitting in an interview one time. It was hard for me to even bring that person back because they showed up in cut off jeans and a tank top and their flip-flops. That's, to me, is not okay. Unfortunately, your generation, or the generation that we have now, they just don't care and they think that's okay. Maybe they weren't, trained, I don't know if that's the right word, or grown, they didn't have those values and they just thought it was okay. But anyways, I decided to go ahead and bring this person back and I'm asking them questions. So I made a first impression of this person and I just thought, this person's just not going to work out. Were they 5 minutes late, to an interview, things like that. But I did give this person a piece of advice. She was young, and then the mother in me came out. You got to be careful with that too, because you can't be their mother and be a professional employer as well. But I did ask, what, can I give you a piece of advice? And depending on their response, and just say, how about we try this again and you come back and this is, or any other employer that you go to. Maybe you might not want to come back, but this is what I would advise for you. And sometimes people will take it well and sometimes they won't, but we have to be sensitive as well. Okay. And be respectful. All right. It does require all employees, again, to be respectful. We have to use appropriate language, honor people's differences, and be prepared to apologize if necessary. I will tell you, it is, if I'm out on the floor or anything like that, I try to be as professional as possible. Sometimes I've gone back in my office or somebody's walked in my office, shut the door, and words have flown in that office, depending on the situation. So I will not say that I am I don't use inappropriate language, but I have to be very careful what I say. Of course, I'm not cussing that person, but you do have to be very careful what you say. We'll talk about that kind of stuff here in just a minute too. Okay. Consequences of not understanding diversity. It can jeopardize communication. It can also jeopardize productivity, work satisfaction, retention, and morale. And it can create a huge liability for you as well. You guys are just too quiet today. All right. Discrimination. It is the adverse treatment in the terms and conditions of employment on the basis of a person's race, color, national origin, age, sex, religion, citizenship, disability, veteran status, or other protected status. And there are several different forms of discrimination, okay? Here's your adverse disparate impact, which is the rejection of a significantly higher percentage of a protected class for employment, placement, promotion, or other workplace activities when compared with a non-protected class. possibly it could be an unintentional result of an innocent act, yet the outcome is still discriminatory. There is a restricted policy for disparate treatment, an employer's intentional unequal treatment or evaluation by different standards of protected class members. You guys are not going to have to remember all of these things, so there might be a few of your test questions that are HR related, but so don't panic when you see all of this information and all these things. That'll be okay. Okay. A bona fide occupational qualification. Okay. That is a suitable defense against the discrimination charge only where age, religion, sex, or national origin is an actual qualification for performing that job. Okay. So can you think of a time when you could discriminate for a job? Can anybody think of a time you could discriminate against a job?
That you could discriminate as a hirer?
Yeah, if you could, is there any time that you think you could discriminate against somebody for a position?
Well, I know that our CEO and our ADO went to a job fair Tuesday here in Oklahoma City, which nobody showed up, by the way.
Oh.
Yeah, I mean, there were probably 250 booths, hotels, everything, and there may have been 200 people there, and there was like dozens there the day before on Monday, FY, because nobody wants to work right now. But anyway, so they had a lot of people in their 70s and 80s want to come to work as CNAs.
Really?
And one of them was in a power chair and probably in their 80s, and they're thinking, you know, because you have to do that lift test and everything. So I don't know if that's what you're getting at, but that just the age and their ability to be able to, when they're the same age and the same condition as our residents,
Right.
how can they take care of our residents safely?
Yeah.
When they're there.
And a lot of times they may not be able to qualify for
Yeah,
that. But
that's what I was thinking of when
can
you
you
said.
think outside the box and you think about other CNA duties, like can I pass ice and water, and can I get them a blanket? You know, you can do like, what do they call that, a T? They have a, I don't hire them, but I can't remember. There's like a tender care associate or something like that. Does anybody know what I'm talking about?
They call them like in our area, like an environmental aid or hospitality aid that just pass ice.
Yeah.
They don't actually do like resident care.
So if you have things like that, that is something that, you know, you could think about for them. Or, you know, how huge is the community? You know, can they sit in the dining room and roll silverware? You know, are there small little tasks for them to do? Is that something that you actually need because it's a full-time job as well, or even part-time? But we will get to thinking about that here in just a minute. So a business necessity, work-related practice that is necessary to the safe and efficient operation of an organization. Okay. If you're having to respond to a discrimination charge, someone comes to you, you know, with a complaint or anything like that, we have to be methodical. We have to meet with the employee who made the complaint. You want to ensure that their information, there is information, demonstrating lack of merit. You want to limit information to only those issues in the charge itself. Seek as much information as possible. Your investigators aren't judges, remember that. And you want to give the EEOC a position statement and prepare for the EEOC's fact-finding conference. I just want to talk about that for just a minute. I also used to work in at a refinery doing HR, and I had a sexual harassment case too that I had to do some investigation on. Those are not fun cases, okay? But I did learn a lot from that position, and it kind of got me to rethinking about how I treated investigations. You know, people come in and they start complaining. Do you think the person that they're complaining about is someone you want to leave out? Do you want to talk to that person? You definitely want to talk to that person because you need to be able to hear what they have to say as well. You want to try to get any witnesses that there might be, so then you don't lead into this he said, she said kind of stuff. Always take good notes. And sometimes, and remember, it is a fact-finding mission is what you're doing. You're not there to judge that person. And you have to be very careful on the decisions and choices that you make. And sometimes you might have to seek legal help for that too, or higher ups to help you make a decision that could be drastic for someone. Okay. Here's a quiz. Victoria's Secret, which is a women's boutique, only hires women. 5 male applications for positions such as a cashier and a backroom stock person. This is an example of what? Anybody know? It would be an example of a disparate treatment. Not a bona fide, qualified, occupational position, but it would be a disparate treatment. Okay.
So would that be grounds for a discrimination case?
Yes, it can be. Mhm. Yes. All right. I am going to offer you guys, again, I really go through this kind of quickly, so I know your break is not scheduled till 10 o'clock, but do you guys need a break? I know you kind of feel like we've only been here for 45 minutes, but are you guys good? Everybody good? Okay. All right. Let's talk about disability now. I hope everybody online is still doing good. All right, Americans with Disabilities Act, or your ADA. So it was first created in 1990 to prevent discrimination against disabled workers. As of 1994, the act covers all private employers and all state and federal agencies employing at least 15 workers. The regulations contained in the act are enforced by the United States Department of Labor and the U.S. Equal Employment Opportunity Commission. Okay, so your ADA. Under ADA, a firm must make a reasonable accommodation to a physically or mentally disabled individual unless doing so would impose undue hardship. That was the word I was looking for a while ago. It just wasn't coming to me, and I apologize. I call it COVID brain sometimes. I still have it. In fact, speaking of COVID, when COVID first hit everybody, my facility in Bartlesville happened to be the first facility, first nursing home facility that was hit the hardest. And I happened to be one of the very first people that ended up with COVID and had to be gone for the first 2 weeks as we're going into this mass transition of, securing, having a COVID unit and putting everybody, making sure everybody's safe and infection control. It was a very scary place to be, and it felt like a war zone. Being gone for 2 weeks and feeling like you have no control of what's going on is a very scary place to be. But I did get hit. I got hit pretty hard. Unfortunately, I lost 20 residents at that time. I got close to, and it's very sad for me still yet, I got close to losing 2 of my employees. I had my ADON, who actually ended up in the hospital, and she was very close to be putting on a ventilator. And, sometimes people don't make it out of that, but we were very lucky that she did. And it took her a little while, but she returned to work, thank God, and she's doing very well. And then I had a housekeeper that had COVID, and she ended up not coming back, which is fine, because, it scared her, and, I don't blame her. And some people don't want to work in that type of environment because of it, but that's why we have infection control, and we follow all these policies, the screening process, making sure that not only are we keeping our residents safe, but we're keeping the employees safe as well, and any visitors that walk in the door, because it's very crucial. So sorry, sometimes I get a little sidetracked.
Actually, when you think about it, just even at that time period, because I remember when your facility had that, because I had worked in public health for 10 years.
Oh, okay.
And so my supervisor was the administrator over there, Alexander.
Okay.
And so I was kind of like still in communication and stuff, and kind of seeing what they were doing, public health was, because I've been out of that area for 5 years. And just kind of seeing, because I'd actually had served as Region 5's emergency preparedness terrorism nurse. So one of it was infection control.
Yeah.
And so as that, I would go to the long-term care centers and help them with their infection control policies, just kind of review it, see if they needed any help.
Yeah.
And so, so when COVID hit, that was something that I contacted her with and said, hey, what are you guys just kind of doing? Are y'all helping in any way?
Uh-huh.
But I did remember that about your facility. But having COVID brain. I still have that. My friend Michelle could tell you that.
Yeah,
I kind of had moments to where it's still a little foggy, but it's getting better.
it is getting
So I
better.
think with time, but it was scary to develop COVID at that time as well, because
Mhm.
there wasn't much known, and then so many were coming down with it. You know,
Mhm.
it was even challenging for people to receive care.
Right.
Yeah, it
Because,
was.
it was still hidden, you never know where it's going to be, and people are still being affected by COVID today. But, and even learning, because with infection control, you're going to learn all of these different policies that you never thought about. Like, what's your policy for PPE, and what's your policy for masks, or what's your policy for, I don't know, there's just so many, and I think, and of course, you've got to have that infection control person that takes over and, does very well. We had to create our own, in-house lab, which we are CLIA certified as well, but, we're COVID testing. We were COVID testing every week, and we in fact just got our county positivity rate down where we can go once a month. And the state has also now allowed us to not have to test those who are vaccinated. So if you're fully vaccinated, you don't have to be tested now too. So there's just a lot of different things that COVID has impacted. But in the end result, some of those things are very good for us it taught us to be more cautious and to be careful and to do our due diligence on making sure that people are safe. Yeah, okay. Did I go over this? I don't remember now. Oh, did I go over that whole slide?
You did.
Sorry. Oh yeah, the undue hardship, that's where I stopped at. Okay, so the consequences of ADA, it can increase litigation. Cases being filed do not reflect congressional intent. The act was passed to protect people with major disabilities, and the law has not resulted in a major increase in the proportion of people with disabilities who are working. So, and we even have a company in Bartlesville, BIOS, and I think it used to be called something else, but you can have people with disabilities that come in, they'll call you and say, hey, I've got John that, wants to come to work. And we've had them come in and, even do housekeeping and end up being really good at their jobs, because they'll really scrub the trim boards and, do all kinds of things. So you've got some people that can really work and work hard. So it's very good to reach out to those places as well. Okay, reasonable accommodation is redesigning the job, modifying work schedules sometimes, or modifying or acquiring equipment to assist the person in performing that job. Just kind of like I was talking about earlier, if somebody has a hearing loss or something like that, can we get, there's a piece that you can attach to the phone, are they capable of doing that as well? Okay. So reasonable accommodation. So when a Walmart door greeter returned to work after back surgery, she asked for her employer if she could sit on a stool while on duty. Walmart rejected her request and she sued them. What was the result? Federal District Court agreed with Walmart that the employee could not perform her duties while sitting down. Isn't that sad? And you wouldn't think that, accommodate that person, let them sit down, let them be comfortable. It's not like they're going to be sitting there all the time. Maybe they want to get up and down, but they would not accommodate it. So I think that's actually a very sad story, but it's something that happens. Okay. Legal obligations may not make pre-employment inquiries about a person's disability. Okay, so remember that you cannot inquire about a person's disability. Should pre-employment. Should review job application forms, your interview procedures, and job descriptions as well. Must make a reasonable accommodation. Employers do not need to allow for any type of misconduct, and we do not have to create a new job for somebody as well, okay? So just remember that. I felt like I needed to say something else here. Speaking of interview questions, do you guys, I did find when I started with Bartlesville Health and Rehab, they didn't really have a set of interview questions. I'm one of those people that likes to have, interview questions, and depending on all the questions that you ask, do you want to ask the same question I mean, because really, if you're asking the same question, it helps you from discriminating. Because you're also, if you've got like a, I'm asking these questions and then I can actually, that COVID rain's coming. But at the end, I can kind of score that person based on how they answered questions. And, you might have some really close candidates there and you can kind of choose based on score, whether or not who may or may not be better qualified for the position. So interview questions are always good. I created a bunch of those when I started. Job descriptions, if you don't have job descriptions for each position, you really should get some of those too. So get with your HR department or yourself if you don't have one and work on them. Those would be some of the things that I would recommend you work on. Okay, sexual harassment. Yeah, he really was going to kill me. We may be done before break. So, are you guys ready for a break yet? No? You guys ready to move on? Okay, all right. All right, sexual harassment. I actually probably need to tell Z he needs to cut my training back a little bit because I never ever go my full time. All right. All right, sexual harassment. It is unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature can constitute sexual harassment when so I want to look at you guys. Okay. Yeah. So submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Okay. Or submission to or rejection of such conduct by an individual is used as the basis of employment decisions affecting such individual. Or such conduct has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. And we'll talk a little bit more about sexual harassment too and some things that I've come across as I've worked. You guys have probably come across some things maybe throughout your careers. Okay, sexual harassment. Employers have a duty to maintain workplaces free of sexual harassment and intimidation. Permissive social climate where employees conduct themselves there's a risk to victims for complaining that complaints won't be taken seriously. I've heard that a lot. I'm not going to tell anybody, it's not going to matter. You do have to take every complaint serious, okay? That's when those investigations come in. And there's a lack of sanctions against offenders. Gender harassment, most sexual harassment victims don't sue or complain, and that is unfortunate, but is the truth. Okay. An employer is considered guilty of sexual harassment when the employer knew or should have known about the unlawful conduct and failed to remedy it or take corrective action, or the employer allows non-employees, customers, or salespeople to sexually harass employees. Because that can happen. You might have a contractor come in and maybe you've got some remodeling going on in your facility or something like that. You've got someone in that is making somebody feel uncomfortable as well. There are several different types of sexual harassment. Let's see. So you got quid pro quo, submission versus rejection, hostile environment, a comfortable subjective response. Preconditions for sexual harassment cases. The plaintiff cannot have invited or incited the advances. Your harassment must have been severe enough to alter terms, conditions, or privileges of employment. The court must determine liability of the organization for actions of its employees. And preventative steps include development of a policy statement, training, a reporting mechanism, and disciplinary policy. It is very important for you to have a policy on any type of harassment, sexual harassment, including that, and having an annual training on those types of things. So that is very important. Okay. Let's talk about who can create a liability. It can be anyone, right? It doesn't matter what your position is. It can be your supervisor, it can be customers, guests, employees, coworkers, your subordinates, even vendors, and it can be anyone. Implications for employers. An employer could defend itself against sexual harassment liability by showing two things. That the employer exercised care to prevent and correct promptly any sexual harassing behavior. That the employer had to demonstrate that the plaintiff unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. Okay, let's talk about examples of inappropriate conduct. There can be touching, sexual comments, pictures, objects, other bases like racial, national origin, age, disability, religion. Where to draw the line? Inappropriate conduct may not legally be sexual harassment, but may still violate your company's policy. So it doesn't always have to be sexual harassment. It can be other forms of harassment or discrimination. I learned one time from an executive director, they talked about something I'd never heard of before. So now I use it, but it's been several years ago. Can anybody tell me what elevator eyes is? I heard that comment one time. No? Okay. So elevator eyes, it might be, I don't know your names, I'm sorry. I guess I should have introduced, had you guys introduce yourselves. But elevator eyes might be somebody, you're looking at someone and you're literally looking them up and down. But how would that make you feel if you had somebody literally checking you up and down? I guess it all depended if you like that person, right? It could be unwelcome, it could be welcomed. You got somebody walking away and you're really checking them out. How does that make somebody feel? Or you've got somebody else seeing it, you know? You have to be careful with those things. It could be innocent little touch, but I can tell you one time I walked in on a person, it was a higher up position and another management person that walked in, and I was watching, it was unintentional, I was just walking in to say something, they had the door open, but that person, the female, had her hands on this man's shoulders, giving him a little massage. How do you think that looked? You think about perception and what that can do. Now me, I just turned around and walked away because I didn't really want to know at that moment. But later on, but it also made me think about, okay, do I need to pay attention to, you know, what's going on here? Is there something going on here? And what am I gonna do about it, right? So it could have just been innocent, but later on, I found out, you know, just rumors, people started talking. I even had our auditors come in, asking questions, and their very first question to me when they walked in my office, which was totally unrelated, they wanted to know what their relationship was. And it shocked me, because even an outside person could see that. So I knew it was a problem, right? So unfortunately, it put me in an uncomfortable position where I had to have that talk and what was going on and things like that. Is it okay to have workplace relationships? Sometimes, yeah. Should it interfere with their jobs? No. Depending on your policy, there are some employers, I don't know who they are, but there are some employers that actually restrict that kind of thing. You cannot have a relationship with someone that you work with. It was inappropriate for these two because they were both married. So it made it even harder on me, okay? Things like that. So when you might have a group of you, it could be 4 or 5 of you getting together and you guys are talking about things and just carrying on, you're all friends, you're cutting up, you're laughing, you're joking, you're saying things that could be inappropriate. Then you have that one person, Susie's walking by, right? And she hears you. And it made her feel uncomfortable. So guess what? She went to somebody. And she complained. So guess what? It opens up to a whole thing of investigation. And now we're having to figure out, what are we going to do? Is it going to lead into, are we going to have to suspend some people? You know, are we going to, I mean, it may mean some more training on, you know, harassment, discrimination, jokes. How far did we take it? Are we going to end up firing all these people? depending on what was said. So you have to be very careful. So joking, cutting up, we all want to have fun and we want to, enjoy our jobs. But you still have to be professional. You cannot let your guard down too much when you're at work. Sometimes it's hard, but even in the break room, right? We still have to be professional when we're in there. Because you might have just that one person again that's going to be not okay with what's going on or what's being said. And it only takes one person. There's a statute of limitations that can go back 3 years, okay? So maybe, I don't know your names. What's your name back there in the pink? Jennifer, what's your name? Aaron. Okay, so maybe Jennifer and Aaron, so I'm picking on you too. Maybe they had a relationship and they liked each other. Maybe Aaron's taken some notes every time Jennifer come up and said something to him, or vice versa. Maybe Jennifer's taking notes, right? And maybe one day, 2.5 years later, they're mad at each other, they break up, things go awry, things aren't good. And now she's frustrated because maybe Aaron has stepped out and started flirting with, what's your name? Amber, right? So now, Aaron, you're quite a little player, right? Okay. Just teasing you. Anyway, so now we've got these little things, we got all these little notes going. Jennifer's got these little notes going. She's mad. And so what's that statute of limitations? We can go back 3 years. That's right. So do not think that what happens today can't affect you a year later, because it can.
Is that on all discrimination, 3 years?
I believe so, but don't quote me on that. But the statute of limitations is 3 years, so don't quote me on that. I mean,
What happened to the couple in your office?
oh,
To the couple in your office?
yeah, I kind of left that alone.
Yeah, I've been sitting here waiting for
So sorry. So actually, there was a very long conversation, and not everything was a fact finding. You really can't prove everything. But later on, I will tell you the upper person ended up retiring. He went ahead and left, so, which was a good thing. And the other person didn't get the position that she wanted either. Okay, so that's how that went, really. And really, we all figured that's what was going on. She was doing everything and anything she could, even, going, getting him some coffee and, but then you find out later, just other things outside of work, things that were going. She knew everything about this person, what he liked, what he didn't like. And, you kind of, and it's okay, because we all get to know each other. We all become family. It's okay that I know that Erin likes blue, or that I know that she likes pink, or you like black, whatever. That's okay, but it's not okay when you start crossing those lines and you really, start doing things that are, under the table, or it could be just a little bit, whatever. You just have to be very careful. That's the point of my story. So yes, the individual ended up leaving, and then she ended up not getting what she wanted. But she did stay. She was demoted. But there we also had to be, kind of ramp up some harassment things and do some, make sure that those annual trainings were going on to kind of keep yourself and taking note, what was your disciplinary action, making sure that those things are happening. Okay, I get sidetracked again. Okay, examples, we went through that. So some court cases, so let's talk about that. So a female flight attendant complained about harassment by a pilot. The airline investigated fully, issued the pilot a written warning, and advised him to stay away from the flight attendant, and conducted that some of her allegations were baseless. The court held that the employer acted reasonably and was not obligated to believe every one of her accusations. Sorry. That also brought me to another thing. I had a med aid and a dietary employee. Okay, this dietary employee, female, and the med aid was male. She became pregnant, not by him, but that I know of. Just teasing. Anyway, she was sitting out taking a break, and he come outside and was taking a break, but he said something about how she looked that made her feel very uncomfortable. And I don't remember his exact words, but it really wasn't appropriate. And, he was looking at, how she, I mean, she was pregnant and he was talking about her, but he was being very sexual with her. So it ended up that after doing some more talking and investigating to, because it all depends on the situation where we are. And I was able to see it on camera, unfortunately. Not all the time are you going to be able to hear things, but I was able to actually see this one. And I had an obligation, which was, do you separate the employees like that? Do you put them on different shifts? Do you terminate them? The med aid actually ended up getting terminated. And it wasn't just that one comment, by the way. The med aid ended up getting terminated. And then later on down the line, the employee actually, she went ahead and quit too. I don't know what happened there, but she didn't have to. She could have stayed. But things like that just can go crazy. But okay, in another case, the employer promptly investigated the plaintiff's allegations against a coworker and placed the harasser on a 90-day probation with a written warning. And the plaintiff sued the employer, claiming that the employer should have taken harsher measures. The court ruled in the employer's favor, reasoning that the employer had acted reasonably and was not obligated to fire the offender to escape liability. So you don't always have to terminate people. You can put them on, you can suspend them, you can put them on probation. And they're walking that fine line, because one more mistake, then we talk about whether it's suspension or termination too. On the other hand, the court ruled that an employer who knew of obscene cartoons depicting the plaintiff failed to act reasonably when he waited until she complained to take the offending pictures down. I worked, actually it was at the refinery. I'm doing a tour in the nitrogen plant, okay, walking around. One of the first things, and that was probably just my HR, otherwise I don't know if I would have thought about it, who knows. I'm kind of a fun person, I can be. I might seem a little boring, but I'm kind of fun. But I go in there and the first thing I see is a calendar of nude women. Or bathing suits. They weren't completely nude. Almost, but you had to really take those. And Aaron, I don't know, you got all of you, some of you guys might have liked that kind of stuff, but really, is it appropriate for the workplace? Would that have been okay? And it's a bunch of guys out there, but we did have some female employees that worked for the refinery and that worked in the nitrogen plant. It could have made them uncomfortable. I made them take it down. So, and I can remember one time I was going to a sexual harassment, and I had just started there, and I was doing some training, and I had took a break, had come back, and there was this piece of paper laying on my desk, and it was one of those handouts that they passed it around, and they were waiting for me, and I picked it up, and I can't remember exactly what it said, but it was talking about whining, and it was really very offensive. And I was like, who did this? And you've got a table of 10 people. Somebody thought that I was going to be the butt of the joke. That, I'm going to tell you, that training session did not end well, right? And there were a lot of people in my office because I wasn't going to take it. They weren't going to push me that way. And so, I had to go to the vice president of HR to figure out how we're going to handle this, right? It didn't happen again. Nobody got fired, but you have to just be careful because somebody just thought that was funny. Now, did I ever determine really who laid that piece of paper down? No, because they were all defending each other, It was okay. That's okay. It didn't happen again. Because then they were all scared. All right. Some court cases. So an employer which fired the plaintiff, a waitress, after she complained of sexual harassment by a cook. The employer reasoned that it was easier to replace a waitress than a cook. Needless to say, the employer lost. Of course they did, right? Wow, what a response to that. And it might have been easier, but wow, that's too bad. So, all right. A waitress was sexually harassed by several male customers, all personal friends of the restaurant owner. The waitress told her employer that she would not wait on those people in the future and that she had consulted an attorney about her legal rights. The employer fired her, despite the fact that she had always been a satisfactory employee. The employer's failure to take any corrective action made it liable on the waitresses sex discrimination charge. Those are just unfortunate, not using common sense kind of things. They can get you in a lot of trouble. Just because they're your friend, you know, don't put yourself in that position. Okay. And if a former unpaid intern filed a suit against the company after what she described as repetitive sexual advances and physical touching by her supervisor and bureau chief. The New York Federal District Court ruled that an unpaid intern should not bring a sexual harassment suit under New York City human rights law because the absence of remuneration disqualified her from employee status. Isn't that crazy? You know, I'm an intern, I'm coming in there. Why didn't the law there take care of her? To me, that is shocking. Too bad that they didn't help her with that. Okay. Any questions about that? I kind of rambled on, tried to make it. Okay. All right, let's talk about interviewing. You guys ready for that break in? Because we're almost done. Look at you guys. All right. All you Zoom people, we're almost done. They're probably thinking, woohoo. All right. Let's talk about interviews. There are different types of interviews. Unstructured interviews, that is where your interviewer asks questions as they come to mind. There's no set format to follow, no standardization. It's less defensible in court. Okay. But then you have your structured interviews, and those are where questions are specified in advance, and the responses may be rated for appropriateness of content. And it's standard across all applicants. Your situational interviews, those are questions that focus on the candidate's ability to project what his behavior would be in a given situation. If you know your boss is 100% wrong about something, how would you handle it? Those things like that, okay? Okay, behavioral interviews. The applicants ask how they have behaved in the past in some situation. You guys have had those questions before. How did you handle this, right? Describe a challenge or a problem that you faced. How did you handle that? Describe a time when your workload was heavy. How did you handle it? Right? And I'm going to tell you, as administrators, you are going to wear many hats. I promise you, you will wear many hats. This past 3 weeks, I have felt pretty overwhelmed because my business office manager, she'd been there 5 years. She decided to take another position. She put in her 2-week notice. So here I am, and really with staffing the way it is too, I didn't really have anybody else that I could bring in there or that I really wanted in there for that position. You know, we're talking about payroll, we're talking about Medicaid, we're talking, you know, billing, all of those very confidential things. And I thought, what am I going to do? So I went in, I sat down and I trained with her, and actually it's good. Because even when you guys were going through your AIT, you know, you had to go through every department and you're learning all of these things, and you get a little bit of tidbit of this. Even with the almost 5 years I've been there, I knew a little bit, but I really didn't have to dig deep in there, right? Because I didn't have to. So I just let them, I'd go and ask questions, whatever, and get what I needed, move on. So now I'm really having to sit in there and I'm learning. So, and I'm actually glad that I sit in there because now I'm learning a little bit more than when I sometimes wanted to know, but I know how to do Medicaid billing now. I knew how the Medicare stuff works more than what I wanted to know. But now I was able to bring in my new person who just started Monday. So I've been training and I had to leave her alone today, but she's okay. So we just finished our first payroll together by ourselves. And I promise you, we went through it with a fine tooth comb. But we got through it. And in between, we're doing Medicaid billing and we're posting payments and we're doing all this stuff. So honestly, I feel like I haven't done my job as an administrator for 3 weeks or in my own office, you know, checking those crucial emails, seeing what I need to do, and fearing that state's going to walk in the door any day because we are in that window right now. They can be in my facility any second. I worry that on my way down here, are they going to call me? Am I going to have to turn around and go back? You know, you just worry about all these things. So you will wear many hats, but you're going to enjoy it. So don't let it scare you. Sometimes you're going to feel stressed out, but other times you're going to feel like, you know, I made that happen today, and the reason why I'm here, but our number one reason why that we're here and what we do, why we do what we do is taking care of those residents, right? Because that's what we're there for. We want to take care of our residents. We want to take care of our staff. They need us, and we need them. So, you know, we're there to take care of those residents. So, and you get really emotional. You get attached to some of them. Some of them you don't. Some of them, they are just like, dear God, what am I going to do today? I've got one individual. He's schizophrenic, and he is also, I hope I'm using the right term because I'm not a nurse either, but paraplegic. Anyway, he's in a chair and can't move his legs or anything like that, but he's very verbal. He can't move those hands, his arms and hands of his, and he will, one second, he is perfectly fine. How are you today? You know, you're beautiful or whatever. The next day, you're a four-eyed, you don't even want to know what he says, you know, all kinds of things. So you guys will have all kinds of different people. And you just have to remember that it's okay. You know, he at that very moment really doesn't know what he's doing. But even if he did know what he was doing, it's okay, because you should just let that just go over your, slide right off your back, right? But you'll have some very interesting things that you come across, some things that will keep you shocked, some things that are good. And you will have employees that test you, but just remember to hold your composure. It'll be okay. You can do it. It's just another day, right? And get through it. But there are some people that just can't handle it and they move on and do different things. And I'm ready for another career, you know, something like that. But this is a rewarding position. It can be very hard, but it can also be very good. And you also have some flexibility, right? Because I don't know about, I do work a lot of hours. I'm not someone that goes in and works 10 or 20 hours a week. I'm there, I'm right in the middle of it, but I'm also not somebody that goes in at 8 o'clock in the morning either. I'll be there by 8:30. If I'm past 8:30, then I'm late, but it gives me a little chance to kind of, you know, sleep in a little bit longer or whatever. Because remember, I'm not a morning person. I don't know what changed. I guess getting past that 40 age made me right? So anyway, we talked about behavioral interviews. Okay, so questions to avoid. When you're doing interviews, you want to avoid these yes/no questions. You don't want just a yes or no answer. Sometimes it's okay to do those, but try to avoid most of those. Your obvious questions. Questions that rarely produce a true answer. Any leading questions, any illegal questions, or non-job related questions. Common interviewing mistakes. Again, those snap judgments. Negative emphasis, not knowing the job. You know, it's hard to ask so many questions if you don't really know the job yourself, right? It can be. Sometimes we have to wing it, but not knowing the job is a mistake. The pressure that you have to hire, like I felt pressured having to hire a business manager, but I still made sure that I had some good qualified applicants because you didn't want to just bring anybody in there. There's pressure. Candidate order, contrast error, influence of nonverbal behavior, attractiveness, race. When I talk about attractiveness, don't think for 1 minute that somebody didn't hire a person, whether male or female, because of how they look, because that happens. It does happen. I'm not 20 anymore. I don't weigh 120 pounds anymore, but you know, people will do that. So that's some of the things that they do, and it can be a mistake. Okay, let's talk about some questions, whether it's legal or illegal. So how old are you? Is that a legal question? It is illegal, that's right. Have you ever been arrested? Okay. Have you ever been convicted of a crime? Right, you can ask that. Can you perform this job with or without accommodation? That's a legal question. That's okay. Do you have a car? That is illegal. You cannot ask them. You can ask them if they are able to, I don't remember how you actually word as far as transportation, are you able to get back and forth to work, but not asking them if they have a car. Because they may not have a car. They may have to hitch a ride or, you know, call City Ride or something like that. So Where are you from? Can you ask that question? No. Sorry. How long have you been working in the healthcare industry? That's okay. And do you currently use illegal drugs? So that was kind of iffy on that one, and I don't remember, and I should have brought it with me, and I apologize for not making any notes. The HR person on here, do you have any side information on that one for me?
Well, from our corporate office, ours asks about the drug use.
It does, right, okay. And when because you're gonna do pre-employment, most places do pre-employment, you're gonna do background checks, you're gonna do drug screens, things like that. Now, if you have a person that comes in and they test positive for THC, what are you gonna do? We are a healthcare facility, so they legally can't work in our facility, right? Because it's under the safety, what is that act called? There's like for healthcare facilities, you can't get somebody that tests positive for that. Now, there's other places, depending on their policy, you know, maybe they'll test positive for that and then say, do you have a medical card? You know, and some places it's okay, but as long as they have a medical card. But is it okay for them to come to work under the influence? No, not ever, okay? But for us, if anybody tests positive on a drug test in our line of work, we cannot hire them, okay?
So if they test positive for THC, but if they have a marijuana card, it would be fine?
Not for us, but for some facilities, for some places, not our healthcare industry. Yeah, there is.
Been like McDonald's.
It just depends on where you are, and honestly, I'd have to go back and look at that, but, you know, it just depends. Now, if they tested positive for any other substance like meth or something like that, meth and, you know, amphetamines or anything like that.
Is between, you know, I'm 21, so I'm legally drink.
Yeah.
I'm not gonna show up at work.
Right.
Yeah.
We can dive into that one a little bit more too. Okay. Measuring effectiveness. So your EEOC claims per year, and these are just ways that you can measure how well you're doing, okay? Cost of HR-related litigation, your percent of minority promotions, survival loss rate among employee groups. Those are just some things that you can look into. There's a lot of places, I mean, just depending on where you live, there might not be a big diverse group of people. You may not have to worry about the percent of minority promotions or anything like that, but it just depends on where you're at. Do you guys have any questions for me? Dang it. Okay. Well, I'm going to go over a couple more things because we did go through our slides, and we all did it before break time. So yeah, I definitely need to work with Zeke on my time, right? So again,
I have a question.
Oh yes, hello.
Hey, yeah, I have a question. Just some guidance on the issue of sexual harassment.
Yes.
And so imagine a scenario where you have a group of maybe 5, 6 male residents who can all gather together and talk, and then perhaps you find out that maybe they've even created a list of the hottest CNAs and nurses. They do the occasional graze of the breast or grab of the butt.
Yeah.
What do you do in a situation like this?
You know, unfortunately, they're not an employee of yours, but you definitely have to have a conversation with that person, and you do have to find a way to put a stop to that, because that is not okay. Because you have to safeguard that employee. Because I have also ran into that where unknowingly, as you know, I'm meeting new residents and someone says, I want a hug. Okay, you just, you know, you give them a hug. This is a resident. You don't think anything about it. But then I want to, you know, they want to play with your necklace, and you realize it's not just a hug because they are rubbing that breast or they're grabbing that butt. And I have one particular resident, and I don't have a really good answer, and I apologize for that. But You as a supervisor, administrator, whatever, you have to put a stop to that because you have to make that employee feel safe. Maybe you go in and you take that employee and you don't let them have any one-on-one with that resident. You always have a second person that goes in there. You let that person immediately know that that's not okay. You report it to their charge nurse, to the DON, but I would not ever let them go in there by themselves. It's not easy to kick a resident out with state, with their Medicaid. You have to have a safe place for them to go. Even if you gave like a 30-day written notice, you can't just do that. So I would recommend, having that conversation with them, let them know what's appropriate, what's not okay. And I would make any progress notes you can on that. And then I would not let those individuals have one-on-one care either. Does that help any?
Yeah, that helps a lot. Thanks.
Okay, you're welcome. Any more questions? I forgot they can do that. Okay. On the Labor Department wage and hour, I just want to go through a few more of these questions. So it does, again, it talks to you about how you can file a wage claim for wage and benefits. We talked about the breaks and lunch periods, or whether they're mandatory. The current minimum wage, again, is $7.25 per hour. Are all employers required to pay minimum wage? Does anybody know that? The answer is actually no. So unless otherwise covered by federal wage and hour laws, an Oklahoma employer must comply with state minimum wage laws if the company has at least 10 full-time employees or equivalent and/or grosses more than $100,000 annually. How often does an employer have to pay its employees? Every employee except exempt employees shall be paid all wages due at least twice each calendar month. State, county, municipal, and exempt employees shall be paid a minimum once each calendar month. You even have like, you work for like school systems like that, they'll get paid. Teachers, it's like once a month. Is my employer required to offer benefits? No. So Oklahoma has no mandatory benefits law. However, if the employer has an established policy for providing for benefits, the employee may or may not be eligible depending upon the employer's eligibility criteria. So you need to read your employee handbook for specific policies. So if you do offer any benefits, depending on the criteria, say that person you're eligible for benefits on the first day of the month following 60 days of employment, right? That might be one of it. So now, and they also have to be full-time. They can't just be part-time. Is my employer required to pay overtime? You might get a lot of questions on that too, on people crossing over on what's overtime, what's not. If the company is required to comply with federal wage and hour laws, time and a half should be paid to non-exempt employees for all hours worked over 40 hours in a work week. And remember, that's your work week. So your work week could be Monday through Sunday, or Sunday through Saturday, something like that, but it's based on your work week. Is my employer allowed to require me to work past my scheduled hours? Employers have the right to schedule the minimum and maximum number of hours that employees may or may not work. Employers can change employees' hours without notice, and they may require employees to work overtime. Okay. It talks about electronic payment of wages. If I give notice but don't work that time, does my employer have to pay me anyway? That's a good question, right? Oklahoma has no mandatory severance pay law. So, however, as with any other benefit, severance may be payable in accordance with employer's established policy. So read your employee handbook. So maybe you've got some people that have accrued some vacation time. Maybe we don't pay out pay time off, but we will pay you for your vacation time if you've put in a written notice, right? And you fulfill that notice. I put in a written notice for 2 weeks, but I just said, I'm not going to fulfill my 2 weeks. Am I obligated to pay that person out? If it's in your policy, no, you don't have to. So they have to watch for that too. If I quit or get fired, does my employer have to pay me immediately? I'm going to go back to the vacation thing. Do I have to pay that person? Not really if they don't follow it, but am I going to? Probably, because I don't want any other legal situations down the road, depending on what it is. Maybe I don't pay over a certain limit. If you've got more than 120 hours, I only pay you for this much, right? I had this recently. Someone told me, you've got to pay me, you fired me. Number one, I didn't fire the person. And no, you don't have to in Oklahoma. So an employer may wait until the next regularly designated pay day, regardless of whether you quit or are fired. Okay. Can my employer deduct money from my paycheck? Deductions can be legal. It just depends on the circumstances. Sometimes you'll get garnishments that come through or anything like that. And yes, those are legal. That's your obligation to do that. But if you are concerned that your employer may be taking illegal deductions, you can contact your state wage and hour unit for more information on that. I was scheduled to receive a pay raise, but never received it. Can I file a wage claim for these back wages? Perhaps you should contact again the wage and hour unit because that's possible. And my employer sent me home early. Is my employer required to pay me for the time I was scheduled to work? Okay. So probably not. Employers are only required to pay non-exempt employees for actual times worked. However, exempt employees must typically be paid their full salary irrespective of the time actually worked. For more information, you can contact your U.S. Department of Labor on that. We do have to put in, and I don't remember how many hours it is, whether it's daily or weekly, but yeah, you are still obligated to pay an exempt employee. I believe I'm being discriminated against or harassed at work. What do I do? You can call the Equal Employment Opportunity Commission as well. You have an employee that's been activated to military service. Will that employee have a job when he or she returns? They may. Talks about the prevailing wage rate in Oklahoma. This is a good question. Is my employer required to show me my personnel file if I ask to see it? What would you do? That answer is no. You do not have to show them their personnel file. You do not want to. Now, what I would recommend if you're ever doing a disciplinary action with someone, maybe maybe it's their performance review. Yes, you're going to give them a copy of that. Okay, but I would never give them their personnel file. Are wages required to be paid when an employee is on jury duty? So if the employee is a non-exempt worker, wages do not have to be paid. So it all depends on, again, your rules that you have. But there is some places that do pay for jury duty because you're also getting paid by the courts too when you're on jury duty. Does my employer have to pay overtime? We do. Oklahoma does not have an overtime provision in the Minimum Wage Act, so you can contact your U.S. Department of Labor. Does my former employer have to pay me accrued vacation, PTO, sick time? Again, that depends on their policy. Can they terminate you for that? Can they terminate you for that? Yes, the only laws protecting your employment are discrimination laws. I'm not really sure what that question is. So can they change my schedule, reduce my hours? Yes. Doesn't my employer have to provide breaks or lunch? Again, the answer was no on that. So those are a lot of good questions that you can get from the Department of Labor, the EEOC, or wage and hour, things like that. So never hesitate to do that. You guys have my business card. For you guys on Zoom, again, I work for Barzell Health and Rehab. My work number, if you're listening, it's 918-333-9545. Don't ever hesitate. Oh, and my email address. Again, my name is Sandra Brown. So my email address is my first initial. So sbrown@BHRC, and that stands for Barzell Health Rehab Community. BHRCmail, MAIL.com. So sbrown@BHRCmail.com. So if you have any questions, don't hesitate to send me an email or just call the facility itself. So anybody have any questions? Well, let's talk to Zine because it sounds like you guys might get a nice long break because I don't think your next person's due till either 12 or 12:30. I'm not sure. So we'll figure out what's going on from there. So thank you guys so much. Again, if you need me, just let me know, okay? Thank you. You all have a good day.
You too. Safe travels back.
Thank you.